isn't easy. Let's talk about Voya, Reliastar, and DRMS. I'm not seeing a lot of these cases these days from these disability carriers, but let's talk about them anyway, because you might have a policy or be a plan beneficiary with these folks. Voya is primarily a health, wealth, and investment company, but they sell disability coverage largely through employer-sponsored benefits, thanks to acquisitions like Reliastar and Aetna Financial Services. They're in the world of ERISA, and on their website, they tout short and long-term disability insurance plans that match your organization's culture and goals. And in reality, that's not the case. They often come with cost-saving features that hurt you because there might be limited coverage for certain conditions like migraines or fibromyalgia. There might be offsets for other income like Social Security disability. There might be discretionary clauses that make it hard to overturn a claims denial. So these are things that sound good, if you will, the idea that this is a big company. But when you pull back the curtain and start looking at the product that they're selling to the employer, there are problems. So let me give you an example. This is a case of Silva versus Voya. It's a Fourth Circuit case, and it upheld a denial because it was a discretionary clause in the policy. And these clauses are basically used as a golden handcuff on a judge to prevent them from substituting their own independent judgment for that of the carrier. And disability carriers know that, and they play the game that needs to be played to successfully argue to the court that they did not abuse their discretion in denying or terminating benefits. Why would an employer plan with Voya be even more risky? What I have found in representing CEOs, CFOs, union stewards is they just don't really understand the coverage that's being offered. They think that they're offering solid protection to their employees, but they never really look at the policy or plan language. And that policy or plan language will often contain limitations that can reduce benefits to just 2 years, or they have very narrow definitions of disability, or they might have offsets that reduce the amount of benefits, or there might be other limitations that you will see in these too late that will limit coverage. There's also the issue of claims handling. Voya has outsourced claims management to DRMS, now known as Full Scope RMS, and it markets itself as a turnkey disability risk management program. In plain English, they're not in the business of paying claims, they're in the business of denying claims. So what do? They demand objective evidence when the policy or plan doesn't require it. They misclassify occupations to argue that the person can return to work. They cherry pick records to support the denial. They play that we need more information game. They will drag out the process to frustrate you into giving up, going away, or ultimately forcing you into litigation, which is not necessarily where you want to be. So how can you protect yourself? Well, if you're an employer and you're looking to buy these kinds of benefits, employee benefit packages for your employees, congratulations, you're well-intentioned. But you need to review the Voya benefit package before you decide that this is going to be offered to your employees. And if you're an employee where Voya is being touted as the disability coverage for you that your employer is offering, I think you need to take a look at that whole benefit package, not just kind of the summary of what they're going to offer, but read the policy or the plan and understand what's the definition of occupation? What's the definition of disability? What is my burden of proof? Do I have to have objective evidence? Is there limitations such as a mental nervous limitation? Is there a subjective medical condition limitation that limits benefits for conditions like fibromyalgia or migraines or soft tissue conditions to just 2 years? And you want to, of course, look for that discretionary clause. It might be that this isn't the best thing for you and that you want to get disability coverage someplace else. Obviously, you want to, if you're filing a claim, keep copies of all the claim forms, correspondence, and medical evidence that you submit. And again, this should be done, in my view, once you've hired a disability attorney to help you understand what this Voya policy or plan has to say. Again, what's the definition of disability? What is it that you have to prove? What's the strength of your medical records? what needs to be done to get this claim filed so that it would be accepted. If your claim is being denied or terminated, what are your appeal rights? What does that claim file say or not say? What are the proof things that need to be developed timely in an appeal to preserve your rights to your benefits? Because remember, in an ERISA case, you'll only have 180 days in which to file an appeal. And that appeal is the trial of your case. You can't wait for a later day to put in better evidence or more evidence. The judge is only going to look at what was in that claims file at the time the appeal process ended. So there's a lot of thinking and strategy and evidence development that goes into these types of cases. Got it? Well, thank you for tuning in this week for our episode of Winning Isn't Easy. If you found this episode helpful, please take a moment, like our page, leave a review, share it with your family and friends. And don't forget to subscribe to this podcast so you'll be notified whenever a new episode drops. Join us next week for another insightful episode of Winning Isn't Easy. Thanks for listening.